Your Honor, do we need her sworn? I was just going to ask if she could make a statement from the podium.
That's fine, if she can just make it from the podium. Thanks.
Raise your right hand to be sworn. You swear or affirm that the testimony you give shall be the truth, the whole truth, and nothing but the truth, so help you God. I do.
Ma'am, if you could just state your name for the record, please.
Sarah Ward-Rupp. Sorry, just one moment.
Sure.
Technology these days. Your Honor, by now I know that you are aware of a note that was found in our Atlanta home while it was being packed up and sold. It was a note found by an estate saleswoman in my parents' bedroom in a closet that my mom had given me for my equestrian apparel. A note that, from the second anyone who has ever seen anything written by my mom would recognize as her handwriting, and a note that I will forever regret not finding myself or it being found sooner, because if it had been found sooner, we probably wouldn't be here. Finding that note was a bigger surprise to any of us than to anyone here in this courtroom. Addressed to my sister and I, the note is incredibly painful for us to read, and it hurts on many levels. It is heartbreaking to read so clearly the anguish that she was feeling. It makes me sad to know that my mom was to the point in her life where she would put pen to paper and write a suicide note. If she had told us her feelings and what she was going through, we would still all be together. It took 2 trials, my dad spending 6 years in prison and possibly more now, for me to stop blaming her and to see the pain that she must have been feeling towards the end of her life. What I've learned since my mom died, as well as through my own struggles, is that depression does not discriminate. It affects anyone of any gender, age, race, belief, and what I think is pertinent here and has been shown recently, financial status. It is something that people feel that they have to hide, and I wish more than anything that she had felt comfortable enough to tell us just how much pain she was in and how close she was to doing what she did. Jolly, the estate saleswoman, finding that suicide note was like hearing from my mom for the first time in 3,123 days. In the note, she tells Mal and I to take care of Dad. Daddy is what she said. I wish I could tell her that we have done our best all of these years. Visiting him in prison, dropping everything just to answer a phone call from him. I got married here in this courthouse, where I've had so many horrible memories just so he could give me away, because we've missed so much already, and I wasn't going to let him miss that. I promise you that the life we have now is not what she wanted when she asked us to take care of our dad. I have the utmost respect for you, this court, and our justice system, but I can't wrap my mind around sending a man back to prison for something he's already spent 6 years in for something that has only made the lives of those affected by my mom's death worse, and for something that was just a tragic accident she had clearly already been preparing for. Out of frustration and out of pain, I have certainly said things that I regret, and I apologize personally to you for those statements. I am very protective of my family, especially my dad, and I sincerely apologize for any disrespect for myself or my sister. I always thought that trials and convictions were meant to bring closure and peace to the victims. My sister and I are considered victims. And in 2 trials, not one person who has loved my mom has testified against my dad. Not one person has slept better at night knowing that he is in prison. No one who ever knew my mom would be happy sending my dad back to prison. And I promise you that this isn't what my mom would have wanted. This isn't justice for Diane. That would be letting my dad come home to me. This isn't justice for her daughters. It's not a win for her sister or for her mother. And it's not what she would want. All I ask is that for once in all of these years, someone listen to us, the people who are affected by this, and even now my mom. Understand that I will always love my mom, and that supporting my dad by no means that I love her any less. But my dad has paid a debt that he did not owe. 6 years in prison. He's very sick and old, as you will hear, and I won't bore you with those details. Sending my dad back to prison is a death sentence, and I am begging you to please have mercy and let us spend whatever time he may have left together. This is not the life that my mom wanted for her family when she was ready to leave us and her pain behind. This is no life at all. I love you, Dad. Thank you for your time.
Thank you, Ms. Murphy. Do you have any other witnesses you wish to call?
No, Your Honor, obviously, I would like to make an argument statement to the court, and Mr. Ward would, whatever order you have, whether the government would go first or whether we go first.
Well, this is the mitigation portion of it, so if Mr. Ward wants to make a statement, now would be the time to make the statement, and then I'll allow the attorneys to make argument.
Thank you. And I will be making the argument based upon the affidavits and the documents we have concerning
Okay, no problem.
health issues in the other matter.
All right.
Mr. Ward, raise your right hand and be sworn, please. Do you swear or affirm the testimony you should give shall be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
You may proceed, Mr. Ward.
Thank you, Your Honor. My wife and I loved each other more than you could ever know, and we had a wonderful, wonderful marriage. I came very close to losing her after we first got married. She was pregnant. I was working in D.C., and the company I worked for flew me back and forth weekly. I stayed in Atlanta. The rest of the time I stayed up in Cleveland Park in a place called the Kennedy Warren, and BF Saul and that thing that I was working for.
Mr. Ward, I'm having a little bit of problems hearing you. Believe it or not, the closer you get to the mic, the worse it gets.
Does it?
So, yeah.
Is
Go
that
ahead.
better?
Yes, that's much better. Go ahead.
It sounded like me in the big courtroom over there where I couldn't hear anything.
No one can hear in that courtroom, Mr. Ward. Go ahead.
Well, what I was going to say is that we both wanted children. We were very lucky she got pregnant right away. And I flew home a couple of times early because we thought she was going to go in. Mallory was being a little stubborn, didn't want to come. So at 2 weeks past due, put her in the hospital and they induced. And when they did, they also gave her an epidural. I don't know if epidural was first or how that worked out. But one thing they forgot to do was they forgot to put a catheter in her. And I guess, you know, when you have the epidural, you can't tell what's going on, but they forgot about that. So they took her down to surgery for a C-section because I guess the fetal heart rate got crazy and they could see the baby was in distress. So they sliced Diane open, and when they do, they sliced her bladder open. And all this urine went everywhere, and she had been in labor for 38 hours. And so the bladder was stretched, and when he made the incision, he cut the bladder also. And they grabbed Mallory real quick, and I'm holding Diane's hand, and I'm just thinking, my God, I just, you know, have this beautiful baby, and am I going to lose my wife? But luckily it worked out. I didn't file suit or anything. I'm not that kind of person. I told the doctor, I said, as long as she's okay, it's fine, and it was. But we raised two great children, and, you know, we came down here to Orlando and had a big company, good-sized company, and just before, you know, we got a credit facility from Wells Fargo Bank, and one of the properties we had just turned out had oil and gas on it up in West Virginia, and the company was worth several $1 billion. I can't tell you what it was worth, but it was worth a fortune at that point. And Wells Fargo, after making a credit facility to us, a month later it called us in default, and so it put some strain on that. And Diane was mad with me. I mean, she said, "How could you let this happen to us?" And I said, "Honey, it'll work out. It'll be fine." But I can assure you that night when this happened, and you know, what I've learned too is that it's kind of a scary thing. And there was police came out that night, and all I know is when they left, we came back a couple of days later, and Diane's jewelry was gone, and some cash was gone. A fair amount of cash was gone. She always carried some cash with her to pay people at horse shows, and also Diane was very, very gracious, and when she'd buy me a gift, and she always brought me nice little notes, she didn't want me to know that she just charge it to me. I mean, she would just give me a nice gift. And, but one thing I've learned, though, is that, you've got a justice system here and you need to kind of fuel it. And I think that the 6-person jury is obviously not a good thing. I was offered a deal prior to this trial, and what I was offered was time served. And I turned it down. And I said, I'm going to fight this thing, and the kids bugged me about it, and Liz Green called me up and said, you've got to take it, and just, go on. Well, we took it, and then it came back, oh, no, we want you to serve 10 years. So you've got some time in. And I said no. And obviously, that was a bad call. What I'm asking for you is, please make this right for me, please. I mean, I'm a good person. I didn't do this. The other thing that I don't like either, obviously, is rebuttal and the closing argument that Mr. J made with the sheet. And, it's amazing how this wine stain showed up. And can you imagine me actually laying down in a bed and saying, come here, Diane, so I can shoot you? I mean, it's just, that was wrong. I mean, and so, but you got a 6-person jury. I mean, everybody thinks the system is fair. It's not. And it's in your hands. And I just hope and pray you let me do this thing for time served and go back to my family. Please. I mean, just, I know this, or the city of Atlanta used to say we're too busy of a city to hate, and I'm afraid there's a lot of hate here. And, here's the old white guy that did well, and we're going to hate on him. And, the media is controlled by the state's attorney's office. And, they get it right sometimes, they get it wrong sometimes. But they got it wrong this time. And Jesus Christ is standing right there. I would swear to him they got it wrong this time, and he knows that. But please have mercy on me. I want to go back to my family. Please. Thank you, Your Honor.
Thank you, Mr. Ward. Anything else, Mr. Gillen? Any other witnesses to call or evidence that you want to introduce?
No, Your Honor. The medical records that are in our pleadings, I will argue from there, but they would be part of the mitigation position that we would take.
So you want the attachments to the sentencing memorandum treated as exhibits for purposes of sentencing?
Yes, Your Honor.
All right. Any objection from state?
No, Your Honor.
All right. The court will consider those to be sequentially numbered exhibits. Do you have the sentencing memorandum? I'll get them for you.
Okay.
Sequentially numbered exhibits for the defense for sentencing purposes. All right. Argument, state.
Your Honor, of course, whatever the state offered isn't really pertinent to your decision, but we did contemplate credit time served based on the amount of time, effort, money that the state of Florida and myself would have to put into this case. And after discussing it with my superiors, as I told them that I would, the offer was for 10 years. But there's a reason, like for example with Mr. Ward, when you get sued for $42 million, you settle for $300,000. That's a settlement. It's not a trial. So that's my response to his point about the offer. You're going to read, if you have not already read, I would imagine you had since you've had it, the medical records. Getting old isn't fun. Just ask anybody who's doing it. And it requires a lot of medical care. Sometimes it requires specialists. And if you're lucky enough to receive that medical care, you receive it. But what I always hear from people in this age range, in their 70s, is that it's better than the alternative. The alternative is what Diane Ward is experiencing. She's been gone now for about 9 years, and she's never coming back. She will never be old. She will never go to Sarah's wedding. She will never go to Mallory's if she has one. She will never see their grandchildren. Every birthday, every holiday, every day is gone for Mrs. Ward. and the jury found beyond a reasonable doubt that it was the result of him, Mr. Ward, intentionally putting a gun in front of her face and pulling the trigger. Couple of points just real quick about the medical records. He did mention on April 26th in a couple of phone calls a couple of things. One, he was going to pass up on the opportunity.
I don't know who he is.
Mr. Ward
Okay.
was going to pass up on the opportunity to go off-site for a doctor visit to make sure he didn't miss a legal call. And he told another person that same day, the stuff about his lung is probably nothing, he's not too worried about it. The next topic really is about the support of his family and his friends. Absolutely, he has it, and even if they believed he was guilty, it would be nice if they still gave it to him in some sense. He is still their father. Nobody can control what they believe. But, you know, and somebody would come down and commit perjury potentially for him. Christina Steinhaus. She was going to testify, and then she was shown what her deposition said, and that was the end of that. So he certainly has charisma, certainly has qualities that people can be drawn near to. But everybody has two different sides, and I think he let some of it show during his statement. But I think there's a couple of things to consider that we've all heard before. How do you treat people who can do nothing for you? And how do you do things when nobody's looking? And without going into the myriad of details through the many, many, many phone calls that I have listened to with him and his family, I would submit to you that there are two different Mr. Wards, and his family would be absolutely devastated if they heard the phone conversations about one another that are had with one another when they're not there and listening. And I think that's just the story of what some people are like. Some people look at people as tools and what can that person do for me at this moment, and if they can't, they have no use for me. And I'll leave it at that, and it just makes him not a suitable candidate for probation or community control. Now the note. We learned a tremendous amount about mental health and suicide from both the first trial, which you had to review the transcripts of for the bond hearing, and during the second trial. And we learned a lot about Diane Ward's mental health history and her physical history through Dr. Sally West. We learned that her primary problem was her anxiety and anxious and being high-strung. And at times on the different forms, she was diagnosed as being OCD or depressed, but never really any criteria or background as to how that determination is made. And she was prescribed a variety of these medications over a very long period of time. And I'm sure you remember that these medications, both when you start them and when you are titrating them up to a higher level, carry certain risks with them, including that of suicidal tendencies. And I think if it's not in the testimony, I think it's common sense that people's moods come and go. People can have dark times, and they can come and go. People have light times, they come and go. The thing about this note is it was written up in Atlanta at some unknown time. I think they believe they can narrow it down to spring of that year or something in regards to a trip to Italy. But that note wasn't Diane Ward on the day that Mr. Ward killed her. The day that Mr. Ward killed her, she was looking forward to going to a horse show with Sarah. And in fact, she was boldly and defiantly not going to be going to her examination under the bankruptcy rules later that week so that she could do so. And she had lawyers working to do that for her. She was reconnecting with old friends on Facebook. And that note was never acted upon. There was never any evidence that there was a suicide attempt by Diane Ward up in Atlanta or down here. In fact, the suicide defense, which was part of the stuff against the wall defense in the first trial was abandoned during the second trial. They filed pleadings stating that they were abandoning the notion of a completed suicide and, in fact, don't let the state even talk about this stuff. That's how the defendant pled his case. So on that particular day, that's what all that information about all the past was relevant to. It wasn't relevant to her past mental health history. It was relevant to her mental health status on that day because they were alleging she wasn't suicidal, she was homicidal, and that she snuck up behind Mr. Ward with a gun in her hand and pointed it in his face, and as he demonstrated on his interview with Channel 13, just 5 or 6 inches from him, and he had to quickly snatch the gun away from her, and it went off. So we have this continued blurring, which began in the first trial between suicidal ideations and homicidal ideations, but none of that was really supported by the evidence. And if we want to go back into the past to talk about the day of her shooting, the day that she gets killed by Mr. Ward, we should also consider what the evidence showed about Mr. Ward. And what the evidence showed about Mr. Ward was he was also drinking that night. She was not drinking alone. He says that on his Channel 13 interview, I was drinking. He won't share with us what he was drinking, and that's fine, but he was. And you can hear on the 911 call when he says 5 separate times that I shot my wife, he's slurring, he's under the influence of something. He, in the past himself, according to the first trial testimony and the previous deposition leading up to it from his brother-in-law, Glenn Sayre, the testimony that you read as part of the bond hearing was that Mr. Ward had indicated several times in the past that he ought to shoot himself in the head to protect his family. So that would seem to be a suicidal ideation as well. And when we talk about being prescribed these medications, if you remember from the photographs that the medical examiner investigator took, there was a bottle labeled alprazolam for Mr. Ward in the photograph, as well as Cymbalta, which is an SSRI, which you heard all about through the testimony of the medical experts, what an SSRI is. It's used to treat depression and anxiety. So really, if we want to talk about the big picture of the past, both Mr. and Mrs. Ward are on equal footing at the day that he kills her. They are both drinking. They both are prescribed, at least, we don't know if he was taking them, but at least prescribed these types of medications. And they were both under tremendous financial pressure, both not happy about the impending examinations coming up of them, and she was going to get out of it so that she could go ride her horses, and the testimony was unequivocal that they had no intent of going, according to the attorneys. I believe it was Elizabeth Green. So when we talk about the note having relevance, there's really limited relevance. It wouldn't warrant a new trial if it was admissible at all because it's not pertinent to that day in question. But let's talk about the facts again if we're going to start casting dispersions about who's suicidal. Remember what the facts in this case are. Mr. Ward has a ginormous wine stain on the back of his shirt and his shorts. Now, of course, according to him, he has no idea how that got there. According to him, he was taking a nap. He wakes up out on the porch alone, makes no effort to figure out where his wife is, and is just going to go to bed. And as he goes upstairs, he goes to the nightstand. He says that he's taking things out of his pockets and placing them on the nightstand, but there's nothing on the nightstand except for a holster to a .357 Magnum and his laptop. So let's turn this back into the evidence and away from his story. In addition to the wine stain on his back, there is wine spilled on the back porch and a broken glass of wine without a hint of anybody trying to clean it up. And what we do have is a holster sitting on that nightstand. If he's taking his things out of his pockets, I would submit that he would have great concern that his .357 Magnum is not in its holster and it's now on the top of his nightstand as opposed to where his witnesses said that it's normally kept. But no concern on his. And then, despite his many frustrations, I submit Mr. Ward has had many frustrations with my rebuttal closing. I do not remember there being an objection to facts not in evidence or an unfair inference, nor one being sustained. So let's talk about the sheet. The sheet does have a pattern that matched the transfer of the 45-degree angle of the wine stain. So now let's ask ourselves, why is Mr. Ward, after having wine thrown on him, because that did not happen to himself, why is Mr. Ward now going upstairs after having wine thrown on him by his wife, presumably, no evidence of a third person being there? Why is he going upstairs, taking a .357 Magnum out of where it's kept, taking it out of his holster, and then lying down in the bed? Who is thinking about shooting whom at this point? And we know from the blood stains on the comforter that there's no smearing and transferring of the blood as would happen if one's legs swept over it if he moved off the bed after that shooting had occurred. So we do know a couple things that predate the shooting and that predate Mrs. Ward coming into that room. And that is him taking the gun out, him leaving the holster on the nightstand, and him laying down, contemplating shooting himself, shooting her, shooting both of them. But regardless of what he's contemplating at that time, what we do know from the evidence and what I did point out in rebuttal is that there is blood spatter on Mrs. Ward's hand, but none on the gun, none on his hands, only on his shorts and on the bed. So even if she was struggling to take the gun away from him, was the theory, there is no evidence of that. What the evidence shows is that he went up there first, he got that gun out, he laid on the bed, and then based on the distances, could have been sitting or standing at the time that he shot her, as Mr. Stuart James explained to you in the jury through the blood testimony and the blood spatter. So that is what we have to consider when we talk about the weight of the note. And that note gets very little weight. Now let's talk about what Mr. Ward deserves as a sentence. He's convicted of manslaughter. He's convicted of doing an intentional act that resulted in the death of his wife. There was no culpable negligence theory, nor was the jury instructed on culpable negligence, or the third theory of procurement that I've never heard of for a manslaughter case actually being given. How does this shape up? How does this size up compared to other manslaughters, such as two people getting into a bar fight, one person taking an unlucky fall and striking their head and dying? Or how does this compare to people shooting firearms up into the air on a holiday and a bullet raining down and killing someone? When you look at the facts of this case that were found to be proven beyond a reasonable doubt to a jury, the facts are that a gun was leveled 12 to 18 inches in front of Mrs. Ward's face, a .357 Magnum, of which Mr. Ward is familiar with. He's very familiar with firearms. He goes to the range. This isn't a little .22 that could potentially bounce off a cheekbone. He points a .357 Magnum 12 to 18 inches from her face and intentionally pulled the trigger. Now, I know they weren't given the option of whether he did that with the intent to kill, but under the Latin phrase res ipsa loquitur, I would submit that at least an intent to commit great bodily harm can be inferred from pointing a gun 12 to 18 inches from somebody's face of that caliber and pulling the trigger. So when you compare this both to the wide spectrum of different manslaughters that can occur, this is as egregious as it gets. And when you compare it to the other parts of Florida's legislature's scheme of how people should be sentenced, I would find it odd that somebody can commit an aggravated battery with a firearm and graze somebody's arm, leaving nothing more than a scar, facing a 25-year minimum mandatory, or shooting somebody in the foot or in the leg or even in the trunk. He shot her in the face with a .357 Magnum from a foot and a half away. He deserves every bit the same 25 years that somebody would get for shooting somebody who survives a graze wound. So whatever mitigation you give due to his age and his medical infirmities, as they may or may not be, should not hold much weight when compared to the actions. And the fact of the matter is that people get old in prison. Young men, many young men, end up getting old in prison because of actions they did when they were younger. And they don't get let out because all of a sudden they're engaged in the natural aging process. So his age and the fact that he's naturally progressing into his 70s shouldn't carry very much weight compared to committing one of the most egregious sets of facts that you can for a manslaughter with a firearm. So we will be asking the court to sentence him to 25 to 30 years. And additionally, we will be seeking the cost of incarceration, if I may approach, of $50 for each day of his sentence that you levied against him. Thank you.
Thank you. Mr. Gillen?
Just one moment, Your Honor. Thank you, Your Honor. This is the sentencing of Mr. Ward. As we say in our pleading, Mr. Ward is a 7-year-old man who is not well. He is a sick man. Now, we know the range that the court, and the court is aware of the range being 124 months or a little bit more up to the 30 years. But what we're asking for and what we believe is appropriate and just is that the court deviate from that guideline, and as we've said in our pleading, to give him time served. And this is the reason why. First, I'd like to talk about, one, the medical. I was struck by Mr. Jay's description and downplaying of the medical situation that we're facing here as the natural aging process. What's happening to Mr. Ward and what he has endured medically in the last 6.5 years is not the natural aging process for someone 70 years old. Now, the reason why the medical issues, of course, is so important, as we're aware, medical issues can be the basis for both mental and physical conditions, can constitute a permissible basis for a downward departure from the sentencing range. And a key thing that we note is the defendant need establish only that he or she requires specialized treatment for a physical disability and that the defendant is amenable to that treatment. And so, of course, he is amenable to treatment, and there is an abundance of evidence dealing with the issue of his medical condition, which I want to go into and discuss in a little bit more detail than has been thus far. The record shows that, in Dr. that the first problem that he has is with the AFib, and that requires close monitoring, very, very close monitoring. there are two medications that he's taking for the AFib. Both of them contain what they call black box warnings. A black box warning is calling attention to the serious or life-threatening risks of taking that medication. So as to the AFib issues, he has one medication, it's Sotalol, which is anti-arrhythmic drug, but that drug can also do serious damage to the heart and the rhythm conditions. So the mere taking of that particular drug, which is necessary for his AFib, creates that black box warning concerning the side effects to his actual life itself. And what is shown is that there has to be quick access to monitoring devices if you have this AFib situation, which would recall for an EKG or a Holton monitor in the case of an acute situation. So we have to have a situation, not just because he's 70, but because he is in a situation where he has so many different medical problems that threaten his life. And the combination of drugs necessary to give him the best chance for survival with his medical conditions. And there's been no dispute, at least from what we've heard today, of the government's position that these medical conditions exist. They are real. They are medical conditions. They're not something that's made up or contrived, or have someone come in and talk about somebody might have an emotional condition or some other non-specific, non-provable condition. These are the medical conditions in Mr. Ward's life. Now, the AFib also, he has to take warfarin, which is a blood thinner, to prevent the stroke as it relates to the AFib. And it has to be monitored by blood testing. So we've got the two, that's also a black box drug. And in particular, as our records show, if the patient is over 65, which Mr. Ward is, then there's a high risk of life-threatening bleeding. So now we have two black box drugs that are necessary, vital for his AFib condition, and both of them have black box warning. That the medical expertise indicates that there must be vital tests done every 30 days. And the concern is that sort of condition available in the Correctional Institute? That's one of the issues, the AFib issue, which is a life-threatening condition for him, not only because of the condition itself, but for the two medications necessary and the close monitoring which would be needed, which frankly, we have deep concern about whether or not that would be available to him in the Correctional Institute. The second condition he has is the ulcerative colitis. And that is a very debilitating condition that he has had for some time in terms of the diarrhea and the bleeding and the flaring up of situations. And that also, just having the ulcerative colitis is also increases the risk of colorectal cancer. And so in light of that, there should be a colonoscopy necessary on a regular basis. Again, this isn't just the aging process for a 70-year-old. Here's a man with AFib, and here's a man also with ulcerative colitis, that in the conditions of which are in any environment are painful and can be humiliating and can be very detrimental to one's health. That's, I submit, particularly the case in correctional institutes where, having a condition over which you cannot control yourself with this ulcerative colitis is compounded by, of course, the restraints that are put on anyone who are incarcerated. So here we have a situation where you've got increased risk of infection, increased risk of bleeding, and there would need to be a vital monitoring, at least biannually, of the signs of infection, and there would be specialists that would be needed in order to examine and to treat him for this situation. And Dr. Douglas's letter indicates also that he's taking steroids now as it relates to that. So this isn't a condition that in some instances an ulcerative colitis can be treated with sulfur tablets or this sort of thing. This is a steroid needed situation. We also have the esophageal reflux disease. The esophagus can be under risk of cancer if this particular situation is not handled correctly, and that would require an examination every 3 to 5 years, daily medication, monitoring daily medication to prevent acid exposure to the esophagus, which could be, as I said, enhancing the risk of cancer. But the medical conditions go on and on. And one of the other medical conditions that Mr. Ward has, and I believe this was determined or identified actually shortly prior to the trial in this case, and that is that there is a mass in his lung that had been identified, and no biopsy has been done on that. It's apparently in the thin lining area of the lung. There is no biopsy that has been done on that. That condition should be monitored closely because of the concern it might well be some sort of cancerous tumor or cancerous lump. This is yet another of the many things that have been put on him concerning his medical condition. Again, the prostate issues, you would need to have yearly PSA testing and digital rectal exams done by specialists. So all of this requires, it is difficult to imagine any 70-year-old, whether that 70-year-old is in a correctional institute or whether that 70-year-old is out walking on the street. It's very difficult to imagine virtually anybody at that age having the kinds of serious, life-threatening conditions that he has. And as I indicated, one of the things that we would ask the court to do is to say, all right, these are real, they're not made up, these are conditions that exist in him, and they are multifaceted threats upon his life that require, even if he were out and not in custody, these would require virtually to handle and to manage all of the myriad life-threatening conditions that he has. He'd be going to the doctor quite a bit to monitor all of these conditions. As I said, 2 black box drugs that he's taking, and then on top of that, the ulcerative colitis with steroids. All of this, we say to the court, would builds up to the point where the court can say, as it relates to Mr. Ward, it would be the appropriate sentence because he has done over 6 years already on this case and has done it in a situation where he's had to deal with the humiliation and the stress and the pain, for example, of the ulcerative colitis while in prison, that the appropriate belief, and we think the fair thing to do, and justice would ask, we think, fairly ask, that there be a departure downward for medical reasons in order to allow Mr. Ward to be with his family, but more importantly, to be outside of the correctional institute so that he would be able to then have the kind of, these are not medical conditions and diseases that can be handled by a general practitioner. These all require specialized, highly specialized training, and in some cases, the use of highly specialized equipment to run tests on him and to keep that monitoring going. So that's something that we think that in fairness, after 6 or 6.5 years, that Mr. Ward should be able to then have the opportunity to be out and to be able to have his medical condition properly monitored in a way that will allow him to live as long a life as he can, given the many medical problems that he has. So that has to do with the medical issues. What I'd like to talk about now is I'd like to talk about the family. And it comes as no surprise to the court or to the state that Mr. Ward continues to have the support of his family, of Mrs. Ward's sister, Paula Seri, continues to support Mr. Ward. The daughters, Sarah and Mallory, continue to support, and I thought that Sarah's statement, I thought, was a very appropriate one and well written when she was telling the court that supporting her father doesn't mean that she loves her mother any less. What it means is that the support for him is based upon their firmly held belief in him and that he did not kill Mrs. Ward. That's what they have believed, they still believe, and what has happened to reinforce that belief. Now, we understand, and we're not here, the inclusion of the suicide note we're not here to talk about, in the context of a motion for new trial. We understand the jurisdictional basis of that in the context of the court had ruled on our motion for new trial, had denied it, and this note was found after that. So I'm focusing on this note in the context of this. I'm focusing on the note in the context of how this note reaffirms and solidifies and strengthens the support that Mr. Ward has from his family. Because really, up until this note was found, and to be clear, I don't think that anyone could possibly suggest that this note was not written by Mrs. Ward. As the court is aware, we have affidavits from Art Anthony, a former FBI employee, former GBI for a number of years. That's all that basically what he did there. And taking family albums, taking well-known handwriting of Mrs. Ward, that's a part of the record, and then comparing that to the note, and that he examined the original note, that it is his conclusion that it's absolutely, or that it's his conclusion that is the handwriting of Mrs. Ward. It is, I think that without a doubt, we're working from one assumption. That note, it wasn't found by any of the Ward children. It was actually found by somebody who was moving the family property out of the house. And the note, but the note is interesting in this respect. As Sarah said, it's really maybe even a crying shame that the note was not found before this case went to a jury. It is a crying shame. But the note has been found. And what does that do? Well, as the court is aware, the note is addressed to Mallory and Sarah. Please let me know how much I love you. I don't know how it happened for me to end up like this. I want you to have wonderful lives, plus I know that I will always be watching out for you both. Take care of Daddy. I love you more than you will ever know. Take care of the dogs. They will need you. That to any neutral observer is a suicide note. And that was a suicide note by Mrs. Ward. A painful but touching and loving letter that she wrote to her two daughters. Now, as as the state said, Mr. Jay said that it was up in Atlanta. It was found in Atlanta. It wasn't found down in the house here, but this was a letter written by Mrs. Ward. What does that do to reinforce the family's firmly held belief in Mr. Ward? This is what it does. Before, the evidence about the state of mind of Mrs. Ward came from her sister, Paula, came from the testimony of her daughters, Mallory and Sarah, and also came from the professional observations of Dr. Sally West. Now, all of that was relevant, and all of that, we believe, was critical to understanding the mental condition and the level of despair that Mrs. Ward had. But now Mrs. Ward, after almost 9 years, is the most important witness as it relates to the extent of her despair and the extent of her mental and emotional instability. No longer do we have to rely on whether or not Dr. Sally Ward's opinions were correct, or what she said when she came in to see her on this day or that day, or the observations of the daughters or of her sister Paula. This is Mrs. Ward telling the family, telling the court, telling the world what was going on inside of her. And this wasn't just, I'm having a bad day, or I think I'm going to write something down in my diary where I'm saying that I'm a little depressed today. This is a very private, very personal, very moving letter to her two daughters, clearly indicating that she intended not to be alive much longer. Take care of Daddy and take care of the dogs. I don't know how I ended up like this. So all of that. Now, what does that tell us? Well, and this again is in the context of what we believe establishes through the witness of Diane Ward, hopefully to this court, because we've already had the trial. We would have loved to have it for the trial, but now we have the sentencing. And what does it tell us? It tells us from her own handwriting exactly what was going on with her. And we believe that it reinforces and confirms what we were saying at trial. And that is, now, I listened to Mr. Jay describe what he believed happened in the room. Now, I believe that he was saying up here a few minutes ago that Mr. Ward took the gun out of its holster, that Mr. Ward had the gun with him in the bed. There's not a single piece of evidence that confirms that. So when we go back and we talk about what we think happened in the room, let's make sure that we understand that there is no evidence, direct evidence other than the conjecture from the state that would afford that kind of conclusion. So what we have, though, is we have this note and we have the interview that was introduced by the state concerning what Mr. Ward remembered in terms of Mrs. Ward kind of being there and the gun being there, and that's what happened. Now, as we remember from the first trial and the record of the first trial, even the state's evidence talked about this 12-inch range. And so the picture which has been presented from the podium here today on behalf of the state is one's supposition, or the state's supposition, about what occurred. What we do know, and parenthetically, there was the argument about Mr. Ward taking the gun down and having the gun. Let's refer back to what the state did or didn't do as it related to the gun. What did they do in terms of DNA testing on the holster? Nothing. What did they do about the DNA testing on the gun itself and on the all-important trigger? Well, they didn't segregate out. They combined the DNA from the trigger and from the grip. And so they deprived the jury of that. Now, all that leads us, and we argue this, of course, at trial, and I know that we argued at trial. But what I'm saying is, when the state stands up and says that Mr. Ward took the gun down and had it on him or something when he was in bed. That is simply speculation by the state. What we do know is what they didn't do, and what we do know is they did mix up the DNA from the trigger and the grip. That's what we know they did. We know that they did not do fingerprint testing over on the side stand of where Mr. Ward's side of the bed was. There is no evidence to suggest that Mr. Ward in any way, and there's one thing that the state said, which to me shows how convoluted and almost desperate their argument is about Mr. Ward being lying down on the bed and then shooting Mrs. Ward. As we know, there was no evidence at all about if there had been an upward shot from the bed, then there would have been, they could have done analysis in terms of where the blood went or what have. I don't think that there was any evidence at all from any witness that said that Mr. Ward, that concluded that Mr. Ward was lying in bed and shot up. That is simply not the case. But what the Channel 13 interview says, and what we believe is now consistent with what Mrs. Ward is telling us. Mrs. Ward is telling us something. In this suicide note, she is speaking to us. And I hope she's speaking to the court on behalf of Mr. Ward, because this shows when we were talking about what we thought was going on with Mrs. Ward. You may remember, we kept talking about her snapping. And Dr. West was saying that she was always on the edge and capable of snapping. Looking at this suicide note and looking what happened in that room, we believe that the evidence now conclusively would cause one to believe, a fact finder to say, you know what? She was snapping. She was on the edge. She wrote this note. It's a suicide note. And that would be consistent with what Mr. Ward said about what happened in that room. No, we didn't have the note. I wish we did. But as it relates to the court's understanding of what is the appropriate sentence here, this note confirms to the family what they have thought all along. And that is one of the many reasons why we are asking the court to depart downward. We've got all sorts of medical issues that we have, all kinds of problems with the medical issues. But we also have the family support. And now there, in our view, Mrs. Ward's suicide note has given them additional support from a real person and from the woman who died here. We believe that Mr. Ward, for the family, for justice, for Mr. Ward, and for the community, weighing it all together, putting it all together, we believe that the sentence which is appropriate would be a sentence in which the court departed down and gave Mr. Ward, he's already been in for over six and a half years. Let that be it. Let the family move on. And let them try to put this behind him. Let Mr. Ward try to get his medical situation in order. And let the family, now having dealt with the suicide note from their mother, let these daughters and the sister Paula, let them now get on with their lives. And we would ask the court to consider those remarks and to make a departure downward. Thank you.
Mr. Gillen. For record purposes, I have attached to the defense's memorandum for sentencing, I have Exhibit A, which is the affidavit of Anthony Douglas, which would be Exhibit number 1 for purposes of this hearing. Exhibit B, the affidavit of Jolie McCaleb, which includes the note that everyone refers to as the suicide note. That would be Exhibit 2 for the purposes of this hearing. Exhibit C is the affidavit of Arthur Anthony and its attachments, who is the handwriting expert. That would be Exhibit number 3 for purposes of this hearing. And Exhibit D is in Delta, appears to consist of letters from the 2011 sentencing that were written to Judge Davis. I recall someone sending me a hospital record from an admission by Mr. Ward. Did someone send me that?
Your Honor, what we did was, instead of attaching Mr. Ward's medical records to the sentencing
Right.
memorandum, we sent you a copy and we sent Mr. J a copy as a courtesy copy so that you could refer to that while reviewing the sentencing memorandum.
Okay, so I did review that for the record, and it was from a hospital admission in January? Is that correct?
Yes.
January of 2018. It, however, was not attached to the sentencing memorandum. Is the defense asking me to make that part of the record under seal because it's a medical record?
We are, Your Honor.
Okay. I'll have to relook. I thought I had it with me, but I don't appear to have it with me. If I don't, I will let you know, Mr. Ellsworth, so you all can resend it, and I can make sure that the clerk's office gets a copy of it. And that would be exhibit number 4, but that one is to be filed under seal.
Thank you, Your Honor.
Does that cover all of the exhibits that I was asked to review prior to sentencing?
Yes, Your Honor.
Okay. State, I wrote, for the record, I did read the state's response to the sentencing memorandum, but there was nothing attached to that that would require being attached as an exhibit, correct?
Yes, ma'am.
All right. Any legal cause I can't pronounce sentencing?
Not from the state?
All right. I have previously adjudicated Mr. Ward. The jury found him guilty of manslaughter with a firearm. The court heard the testimony at the trial, also closely observed the forensic evidence that was admitted. I have reviewed as I've stated, all of the records that were presented to me on behalf of Mr. Ward. He does have several medical conditions. However, none of those medical conditions are medical conditions that cannot be treated at the Department of Corrections and aren't routinely treated by Florida's Department of Corrections. At this time, the court does not find a reason to downward depart in this case. Based on the totality of circumstances on this case and the facts and the evidence that I heard at trial, court hereby sentences you to 30 years in the Department of Corrections with credit for. Give me his time in the Orange County Jail.
The total in the Orange County Jail is 138.
He has 138 days in the Orange County Jail.
The total is 6 years and 95 days.
All right. So total would be 6 years and 95 days. DOC here calculates their own time, so they may slightly change my calculation. The one that is set is the one for our Orange County Jail time. I'm ordering restitution per Florida statute 960.293 in the amount of $50 per day. For the length of the 30 years, I'll have to do the math. I don't know what that total is. So I'll add that up, make that an order. Court costs are $418. $100 cost of prosecution. Is there an investigative cost, Mr. J?
We'll waive it.
Waive? All right. Anything else from state?
No, ma'am.
Anything else from defense? You have 30 days to appeal the judgment and sentence of the court. If you cannot afford an attorney, one will be appointed to represent you. Good luck to you, Mr. Ward. This court's in recess. Can you? I'll do it also. I'm just going to do 50 times 365, right? Or 50 times 30. Times 30. I am calculating $547,500 in restitution for cost of incarceration. Any objection from state?
We will waive the leap year costs.
Yeah, I skipped the 1 year. Any objections from defense as to the calculation? Mr. Gillen? I calculated 30 times 365, skipping leap year issues, and came up with $547,500 in restitution. Any objections to that amount? It's under statute. All right. Thank you very much, gentlemen. Have a good day. The cost in the $547,500 is reduced to a civil judgment.